Good afternoon. My name is Ala McCoy. I am Director of Startup Support at the University of Maryland's UM Ventures. And I would like to extend a very warm welcome to everyone who came to our today's session for the next installment in Startup Fundamentals Workshop Series, both our live audience and those watching the session on our Startup EMD YouTube channel. This workshop series is offered by UM Ventures and Maryland Technology Enterprise Institute. Everyone in our live session, please feel free to submit questions using the Q&A function. You can find that at the bottom of your screen. Questions always make a session more interesting and more relevant to you. So as a reminder, this session is recorded and we're posting it on YouTube. So if you would like to remain anonymous, please select the Submit Question Anonymously option. You can also, if you want, raise your hand. And I can unmute your microphone and you can ask your question that way. But again, remember this is going to be on YouTube and just keep that in mind. So today we will continue discussing intellectual property. At the last session, we talked about patents and copyrights. And today our speakers, Alfonso Chen and Kathleen Tierney of Cahill, Gordon, and Reindel are joining us for part 2 of Intellectual Property Fundamentals, where they will talk to us about trademarks and trade secrets. What do they protect? How do they work? How to get them? And how do they fit into a startup strategy at different stages, which is probably the most important part that's hard to find just by a simple Google search. So thank you so much, Alfonso and Kathleen. I'm going to give the microphone to you. I am here in the background. I will be monitoring Q&A, and the floor is yours. Thank you again.
All right, thank you very much, Ala. And thank you, all of the participants, for joining today. We very, very much appreciate you joining us in this session for the university. I think it's going to be a good session. We're going to try to reserve time at the end so that way we can answer your questions. So feel free, as Ala mentioned, to use the Q&A button on the Zoom workspace to provide your questions, and we'll try to answer them either during the course of our presentation or at the end. So since Kathleen and I are both lawyers, we would be remiss not to provide you with a legal disclaimer. So I'm going to go read that right now. So the information presented here is for educational and informational purposes only and does not constitute legal advice. No attorney-client relationship is formed by your attendance or participation in the seminar. The views and opinions expressed in this program are those of the speakers and do not necessarily reflect the views or positions of their firms or employers. The content is provided as is and should not be acted upon without seeking professional legal counsel. The speakers and organizers disclaim all liability for actions taken or not taken based on the contents of this presentation. So with that said, thank you again for joining. Let me give you a little bit of an introduction. During our last presentation, we've had the pleasure of discussing patents and copyrights. And also we touched on trade secrets and trademarks. It was sort of an overview type presentation. Now we're going to dive deeper into specifically trade secrets and trademarks. And I'm going to turn it over to my colleague, Kathleen Tierney, and we're going to go through this presentation to discuss these two very different but very important aspects of intellectual property. So with that, Kathleen, please take it away. Kathleen, I think you're still muted here.
Thanks. Can you hear me now?
Yes.
Perfect. All right. Hi, everyone. As Alfonso mentioned, we'll be going over two main types of IP. The first one is trade secrets. What is a trade secret? A trade secret is any information that has value by virtue of not being generally known. And this value comes to competitors who cannot legitimately obtain the information. So this is really anything that gives you an advantage against a competitor that would be highly valuable and worth protecting. Examples include the Google algorithm, the search algorithm that is constantly evolving, but is not generally disclosed how it works to the public. Coca-Cola's famous recipe has been a trade secret for over 100 years. The Kentucky Fried Chicken recipe, these are things that are out in the public and being sold, but the actual mechanisms of how it's made are not disclosed in any patent application or in any other public materials. And to the last point, it has to be subject to reasonable efforts of secrecy in order to maintain its protection. Misappropriation of trade secrets occurs when a trade secret has been wrongfully taken or disclosed without consent. And there are legal protections for it, which we'll get to on the next slide.
But before you go to that, I want to give a couple of examples in your context, perhaps as a researcher or as a startup. A trade secret might be as simple as your customer list of who your customers are and your relation and details about your relationship with your customer. It could be as simple right now as your inventor notebook with data that you've been accumulating. Either when I say notebook, that could be either physical or electronic, with important information that's gleaned from your research. So, there are a lot of things that could be covered as a trade secret that falls within this very large umbrella. So, please continue.
There are two main statutory frameworks for trade secret protection, one at the federal level and one at the state level. Trade secret protection traditionally has operated at the state level. The primary statute is the Uniform Trade Secrets Act, which all states except New York have adopted in largely the same format with slight modifications. But in 2016, a federal statute, the Defend Trade Secrets Act, was passed that provided remedies and recourse at the federal level as well. There are some differences between the two. Notably, both have a 3-year statute of limitations, and if you are pursuing a claim in federal court, you can bring an action under both statutory frameworks.
So in Maryland, you have the Maryland Uniform Trade Secrets Act. So it's readily available, as well as, of course, the recourse to the Defend Trade Secrets Act.
So the DTSA, the Defend Trade Secrets Act, has some differences from the UTSA. It has a slightly broader definition of trade secrets. So certain claims would have more coverage under the DTSA than the UTSA. But I'd say the biggest difference is in the remedies that it provides. The DTSA allows for seeking civil ex parte seizure of proceeds and physical objects. You can get whistleblower immunity if you disclose trade secrets in the context of a civil litigation in narrow circumstances. You can receive higher punitive damages. I believe it is double the amount of punitive damages. There's also criminal liability under the DTSA. Someone who is found to have misappropriated trade secrets can be held criminally liable.
And let me add just that ex parte seizure. What that means is that if there's a violation under the DTSA of a trade secret, what can happen is that and if you prevail, you can actually send, for example, federal agents and marshals to go and seize the fruits of that misappropriation. For example, seize products that were made according to that trade secret improperly, or you can seize the data or information from that infringer's facilities. So it could be a very powerful tool under the DTSA.
We'll go into a couple examples of high-profile cases for trade secrets. The first example is Waymo versus Uber. which was heard at the federal circuit level in 2017. It's a classic trade secrets case wherein an employee of one company leaves that company, downloads or already knows trade secret information, goes to another company and uses that trade secret protected information to profit at the new company. So a former employer of Waymo downloaded thousands of confidential documents, left to start a self-driving truck company, which was subsequently purchased by Uber. Waymo brought suit. They went to trial. 5 days into the proceedings, the parties settled, and Uber agreed to pay $245 million and to stop using the IP. In addition, the former engineer who had misappropriated the trade secrets was sentenced to 18 months in prison.
So this circumstance in which there's this type of former employee violation comes up quite a bit. I've been involved with cases where the technology ranged from everything, including, let's say, the glass that's on your cell phones is made by a special process owned by Corning. And there was an engineer who was disgruntled and ended up trying to pass off and sell those trade secrets on how to make that glass to some Chinese competitors. There's also another case involved where there were plans on how to construct semiconductors that were taken literally on a flash drive, from one competitor to China, and that came up. So, these things come up quite a bit, especially with employees or even business associates that we were working with that may have suddenly a difference of opinion and want to pursue, other means of monetization.
The next case has a somewhat similar fact pattern. It involved digital radios. The Motorola brought suit against Hytera, alleging that Hytera had hired several former Motorola employees. Those employees allegedly stole thousands of documents of trade secret protected material, which Hytera then used to produce competing radio products. The interesting thing about this case is that it included international sales of these radios. The court in this case ruled that the DTSA could have extraterritorial reach to cover damages in a foreign jurisdiction if the acts of misappropriation occurred in a domestic U.S. context. So in this case, Hytera had been using trade secrets at its U.S. trade shows, and the court ruled that constituted a domestic act of misappropriation. So this is a new development in the law affirming that you can receive extraterritorial damages for sales for domestic misappropriation.
In the two cases that I mentioned where the trade secrets were taken to China, this is very important because that's typically the tactic is, hey, well, let's try to get this information, get it out of the U.S. as quickly as possible so they can go and utilize it. But this helps extend the jurisdiction, of what's happening, of these bad acts overseas.
Sure. So as a brief overview of trade secrets versus patents, most companies commercializing products will have both types of IP, but they operate in very different ways. So trade secrets require maintaining secrecy, whereas patents require full public disclosure of the invention. Trade secrets notably can last indefinitely so long as the information remains secret, is not independently discovered or reverse engineered, which is a potential exception to trade secret protection. Patents, on the other hand, only protect for a fixed term. It's usually 20 years. Trade secrets offer narrower protection, but again, they last indefinitely and allow you to maintain a competitive advantage in a lot of instances. So there are reasons why you would choose one or the other. For instance, in Coca-Cola, they could have patented their recipe, but at the same time, it would have expired in 20 years and all of their competitors would have known the recipe from the beginning, their decision not to patent it and keep it as a trade secret has allowed them to maintain protective competitive advantage over the recipe for over 100 years. So I think in that instance, it has paid off for them.
Just one thing of note, sometimes there are inventors and companies that try to do both. They try to maintain a trade secret as well as patent their technology. But it can be a very dangerous type situation because of the requirements for full disclosure by the patent law. You not only have to disclose and enable their inventions, but you also have to disclose your best mode. That is the best way of making and using the invention. And if you withhold that best mode, that can invalidate their patent. And so a lot of times for safety's sake, you have to view trade secrets and patents as almost divergent, means of protection.
Moving on into trademarks. What is a trademark? A trademark is a legally protected word, phrase, design, or a combination thereof that identifies your goods or services. It distinguishes them from the goods or services of others and indicates the source of your goods or services. As you can see from the photo, it covers logos. It also covers slogans. Think Nike's Just Do It. What are the other ones? I don't know. McDonald's has one about happiness. But speaking of Coca-Cola, even the shape of the bottle, the contoured glass bottle, that is something that can receive trademark protection as well. And a trademark is protected from being registered by others without permission, and it prevents a similar trademark being used for related goods and services. And the intent behind trademarks is to prevent consumer confusion by identifying the source of the products or services. So you don't have two products in the market that look similar, that customers might think, oh, they're purchasing one thing, but they're getting the other.
So we're going to go over a few examples here of different types of trademarks, especially how it can affect you. But continue on, and we'll go over those toward.
So the primary statute that enumerates trademark protection is the Federal Lanham Act. It governs trademarks, it governs service marks, and it governs unfair competition. It is intended to protect brand owners from infringement, dilution, and false advertising by creating a national registration system, and it allows private rights of action for consumer confusion.
Oh, let me just clarify one point here. Let's say the issue about consumer confusion between marks. So let's say there's Coca-Cola on one hand, and then you have Cookie-Cola on the other hand that sound very similar. And let's say they both use the same curved bottle, and have a script for the name Cookie-Cola. Well, that could cause confusion among the consuming public who say, oh, I thought I was buying Coca-Cola, but it was actually Cookie-Cola. Okay. So generally, you want to be able to distinguish the different brands that way. But then there's also dilution. Dilution means you're not really confusing the public, but you're diminishing the value or the recognition of a famous mark. So let's say a famous mark would be, let's use Coca-Cola. Coca-Cola is a famous mark. People around the world know Coca-Cola. But then let's say I am starting a company called Coca-Cola Candy, okay, or Coca-Cola Tobacco. Okay, let's call it Coca-Cola. And so Coca-Cola doesn't want to go into the tobacco business and have their famous mark affected or known as a mark for tobacco. And so that could cause dilution of their famous mark. So that's just one example there. So because the trademark owner should have the ability to control how and where that mark is used. And so anything that would diminish that control is called deletion.
We have a question about trade secrets. Do you want to save it to later, or do you want me to read it to you now?
Let's address it now. I think it'd be a good time now.
Sure.
So I'll
And
let you
actually,
mention it.
yeah. So the question is, if trade secrets can be reverse engineered, what's preventing someone from reverse engineering it and selling it under a different name?
Okay, that's a really good question because this happens a lot. And it's actually not illegal to reverse engineer. You can do it. If the item is protected as a trade secret, yes, you are totally capable and allowed to go and reverse engineer that product. For example, for the Coca-Cola example, you can go and reverse engineer Coca-Cola, the formula, and see exactly what are all the constituents in it and try to replicate it. In fact, before this, I saw some YouTube channels in which someone actually did that and tried to replicate Coca-Cola. And there's entire industries that are based on doing reverse engineering, trying to ascertain exactly what the formula or the makeup of different products are. So totally proper, and that's one of the risks of going to trade secret protection.
Thank
Sort
you.
of distinguishing that also, if you had a patent and you reverse engineered it and you copied that same design, well, that could constitute patent infringement, even regardless of whether you've reverse engineered or not. But again, your patent protection is only for 20 years, not indefinite like in length as trade secrets.
Got it. Thank you.
So we'll go over a couple requirements for trademark eligibility. The two key requirements are that the trademark must be used in commerce and it must be distinctive. There's also the functionality doctrine is a trademark cannot be essential to a product's function, thereby placing competitors at a functional disadvantage. If anything in the trademark indicates that for example, I would imagine like an orange traffic cone. You couldn't trademark an orange traffic cone because all of the competitors of traffic cones would want to be using the color orange. That's an example of the functionality doctrine.
Let me just go over this. Let me go back to the use in commerce. So this is important. So you just can't decide, okay, I'm going to have a trademark, but then never use it. You actually must use it in commerce. Now, you can register a trademark with an intent to use, and then after some time, submit evidence of actual use. Okay, but you actually do have to use a trademark in commerce. So if a trademark is not used in commerce and is left outside, then after that, you could lose protection in that respect. Other part about it being distinctive, that's true. That sort of touches on that first point that Kathleen raised and we discussed earlier about you want to avoid confusion. So the marks have to be distinct enough so that the consumer won't confuse one mark from another. So
I love Chip.
We'll go over a couple of examples. This first example, Qualitex v. Jacobson Products, is a landmark case. It's an interesting case. The Supreme Court addressed whether a single color could qualify for trademark protection under the Lanham Act. The petitioner sought to protect the green gold color of its dry cleaning press pads as a trademark. The respondent was a competitor who challenged that you could not trademark a color, the court actually ruled that a color could function as a trademark if it served to identify and distinguish a product's source and was not functional. The court emphasized that the Lanham Act's definition of trademark is broad enough to encompass colors, provided they have acquired secondary meaning, meaning the public associates the color with a specific source of the goods.
Now, not every color and not every sensory perception can necessarily be trademarked after this Qualitex case. For example, Harley-Davidson tried to trademark its distinctive, rumble of its engine, which has this sort of potato sound. And the trademark office and the court said, no, you can't do that because that sound is something that's perceived, and that perception is subject to subjective variance. And so while one person might hear that sound is imparting one particular sound, there may be others that hear it differently. And so in that sense, that's considered, sound is considered to be, in that particular aspect, considered to be not trademark protected. But of course, there could be different things. Jingles, things could be, trademark. For example, the startup sound for Windows or the certain ringtone on a phone. Those are very distinctive. So that can be trademarked as a sound that would be distinctive. So it really depends on the circumstance and whether it can be objectively distinguished from others.
This was a recent high-profile case, OpenAI Inc., the Open Artificial Intelligence Inc. The interesting thing about this case is that Open Artificial Intelligence founder registered his open.ai domain before OpenAI was founded. It didn't properly register the trademark, but the court focused on the question of secondary meaning, whether OpenAI had superior or senior trademark rights because OpenAI's products had been established in the market. The court found that OpenAI's products and their popularity, including ChatGPT, were far more well-known, had far more consumer recognition than Open Artificial Intelligence Inc. And the court, even though OpenAI had been registered first, the court ordered the USPTO to cancel Open Artificial Intelligence Inc.'s trademark registration and enjoined the company and its founder from using the name. So this highlights the importance of secondary meaning and the establishment of consumer confusion and consumer recognition in the enforcement of the Lanham Act.
One point here is that Kathleen noted is that OAI did not properly register its mark, though it did. Afterwards it didn't police it. Like, for example, I remember I mentioned you need to go and file evidence of use and continuous use after that to show, hey, I'm continuing to use my mark. They didn't do that. Okay, OpenAI didn't do that. So if they had, our Open Artificial Intelligence, OAI didn't do that. But if they had done it, it would have been much more difficult for OpenAI to make these arguments because, they could show that, hey, look, OAI didn't take all the actions in order to protect its mark as required by the statute. So I'd like to go over, some of these costly mistakes that could affect you as a startup, as an incubated company, or as even an innovator who's thinking about creating a new business. First, not properly registering the trademark of the patent office. And we saw this here in the OpenAI OAI case. There's a lot of procedural requirements that you need to satisfy in order to properly register your trademark. One is conduct a clearance search in the patent office and the trademark office database, okay, to make sure that you're not going to be confused with the different mark. There's a very nice search tool that's available at the at the trademark office, where you can, for example, insert a name. Like let's say my name was Cookie Cola, and it could help. You can find other marks that are close to that. There are also other searches that you can, like for example, on Google image search, you can go and search an image to see if that logo, a similar logo, is being used. So, something do that searching, because if you can show to the trademark office that, hey, look, I've done a search and here's everything that has come before that's close and nothing has come up that anticipates what I've done, that will go a long way in helping the trademark office accomplish the proper registration. The second part is to identify the correct owner. This is a pretty big issue. You think, oh, that's pretty simple. That's me. Well, not always, because trademarks can be trademarked by the company, the one who's doing the commercialization. So in this case, remember the OpenAI and the OAI case, the founder was the one who trademarked this mark initially, but it was actually the company that is the one that owns it. You need to make sure you identify who the proper owner is. Is it an asset of the company? Is that an asset of the individual founder or an employee? You need to make sure it's clear. Typically in your cases, if you do set up a corporate structure, you need to make sure it's clear as to who owns what IP that's the product of your company. So that's important as part of your formation documents. Be clear, for example, you may want to have a policy where all inventions, all trademarks, all copyrights are owned by the company, or you may have a different policy because there may be multiple contributors where each of the assets are owned separately by their contributors. So make sure that's delineated at the start, so that way you have very clear understanding of who owns what. The other part is be distinctive in your wording. Don't use descriptive, generic, or functional names. For example, if I'm trying to market a tea, for example, going along the lines of we're talking about a lot about different types of drinks, and I call my tea brown tea. Well, that's pretty generic. All tea is brown or green, and I just happen to pick, one of the major colors. That's not very distinctive, or if I use the term just tea from tea leaves, again, that's just too descriptive or generic of what it's coming from. But if I use the term something much more fanciful, like tingly tea or brownie tea, and I spell it BROWNIE, brownie tea, a little more distinctive and more not as generic. So I might be able to get a registration for that mark. So that's another aspect of it. The other aspect here is make sure that you classify your goods. Okay, because when you register your mark, you have to actually specify what types of goods or services are going to be covered. You have to specify, is it going to cover, for example, when I say, let's say my mark is brownie tea. Okay, is it going to be food and drink? Okay, is that all I'm going to cover? Am I also going to cover paints? Like I might say, oh, I want to have brownie tea and then sell a series of tea infused paints. Okay, do I want to cover that too? Do I want to cover merchandise like my t-shirts? Do I want to cover mugs? Do I want to cover packaging and boxes? You have to think about all of the different permutations of products and services that you may want to apply this mark, this trademark, in order to distinguish your product and services from others. So you have to make sure that you specify all these different categories. Of course, when you specify more categories, the trademark office is going to want more filing fees. Okay, but you need to make sure you protect it, because let's say if I decided I only pick brownie tea to be foods and drinks, but then after that I wanted to have brownie tea mugs, well, I may not be protected for brownie tea mugs. Okay, so very important about this. And then not renewing trademark rights, you have to make sure that you maintain your trademark rights every 5 or 6 years initially, and then every 10 years after registration. that, like we had talked about before, you could file an intent to use a trademark, but then after that, you have to make sure you submit your evidence of use. And then I thought you have to make sure that you're always renewing that trademark registration, showing more evidence of use. You haven't let this trademark registration lapse because of non-use. Because once you let that lapse because of non-use, everybody else can use it. So let's say my trademark for brownie tea, after 3 years, I never used it. Well, someone else can go and take it and use that. You got to make sure that you're diligent about maintaining it. Because the patent office is going, and the trademark office, they're not going to send reminders to tell you, oh, by the way, your trademark is going to lapse, your registration is going to lapse because you didn't do anything. So make sure you do that. Alla, I'd like to address one of the questions that was just raised. Perhaps, Alla, can you read that and I'll answer that?
Absolutely. So here's the question so everybody can hear it. We are academics and gave our IP software a boring name 10 years ago, and this name was recently ruled as descriptive by USPTO, so we cannot trademark it. What are the pros and cons of changing the name so it's trademarkable as we spin out our business? The software has been described in 10 years of research by the descriptive name, and it has an existing user base.
That's a good question, because a lot of times when you are developing your software at the very beginning, you're not thinking about trademarks. You're thinking about developing your software, right? But then, sometimes the software, as you mentioned here, it can it can be viewed as descriptive. So it's describing its function. And so it's not trademarkable. So, ways that different companies have taken software in particular and attempted to add some distinctive nature to it is, for example, you might see many types of software be actually an acronym. Okay, so for example, you might have heard like Fortran or BASIC. Okay, those are actually acronyms for things. Okay, those are not just like the server software. Okay, you may want to use that, figure out some type of acronym for it, or some play or variant of the original boring name that you gave 10 years ago. So let's say the name of your software was, let's say, the data compiler. I'm just making this up. So maybe you want to call it something else. You want to call it data compiler and spell compiler with a Y instead of an I. Okay, to show that it's something distinctive. It's not like your normal name. This is actually a specific name. Okay, so those are some different examples. And they're just making this up. But usually, a good trademark attorney can help you come up with some ideas or variants to give that that name something less descriptive and more distinctive. Okay, so that's why you see, for example, different types of modern software, like they use terms like open AI or chat GPT, or even though GPT might be descriptive, but they added chat to it, so that now is distinctive. Okay, those variants can help transform a previously descriptive software name into something more distinctive. So I hope that helps answer the question. Kathleen, do you have anything else to add to that, or any other thoughts?
No, I mean, that makes sense to me. I was just thinking in the OpenAI case, there was the fact that there was no space between OpenAI, distinguishing it from open space AI was relevant. Yeah, just sort of like you said, the Y, you can change the spelling. It often doesn't take a big change functionally in the name to get trademark protection.
Go to the next slide, please.
It's gonna wait.
Okay, so one other aspect here is not considering international protection, right? And this is really important, as as Kathleen mentioned, in the trade secret situation, only recently was international protection or some measure of international protection afforded by the DTPA, by the Federal Defend Trade Secrets Act. Before, what could happen is that trade secret could be taken to China or anywhere over the border, and then your trade secret protection was gone. Similarly, trademarks, if you're not trademarking in every jurisdiction, your trademark rights may not be enforceable outside the US. So let's say, for example, Coca-Cola didn't trademark their mark in Canada. I'm just making this up, or Mexico. And so someone there decided, you know what, I'm just going to start selling my own Coca-Cola in Canada or Mexico. Well, that could be very, very confusing, especially when people are coming over and crossing the border or selling goods across the border. And but Coca-Cola may not have a right to exclude or protect their trademark in the US because of this extraterritorial aspect. So that's really important. I think we really have to think about, where do you plan on marketing your product? Is it just going to be domestically in the US? Are you planning on going international? Are you planning, for example, on, let's say it's a trade secret, are you going to have collaborators or customers that are in foreign countries? You need to consider those factors in determining whether you want to even use trade secrets, because some countries, they don't respect trade secrets. They don't even have trade secret laws. So you may have to really consider whether trade secret is the route you want to go, because you may have protection here in the US, but you may not have protection where your customers might be located. So those are all factors you have to really consider. The other aspect is not policing the mark. And I'm gonna expand this also to not, you have to also police your trade secrets as well. You have to make sure that you're protecting your mark. So let's say in my example, my brownie tea, example, if I find out there are competitors out there saying, oh, I'm selling brownie tea too, and I'm not doing anything like sending a cease and desist letter to them, or I'm not contacting them and telling them, hey, you can't sell that, or telling the stores that, hey, this is an infringing mark. If you're not doing anything to protect your IP, your trademark, well, then you're essentially saying that my trademark is not worth protecting. It's sort of like, think about your property. You say you have some land, okay, and then your land is your exclusive right. It's your home, but then you let all the kids and all the neighbors and all the animals and the trucks just park on it and traipse through it, whatever. If you let them do that with impunity, well, then the assumption is that that's the practice. That's your course of conduct, and you allow others to trample on your property. So you've given them either an implicit license or understanding that you're not going to enforce your exclusive rights. So you really need to make sure if your IP is worth protecting, you actually take actions to protect it. Otherwise, those rights you just can't selectively protect them when or whenever you want. You have to be diligent about doing that. You have to actively monitor what's happening out there in the marketplace. You have to be attentive to what your competitors are doing. Similarly, on trade secrets, remember, one of the requirements of trade secret is that if you have to keep it a secret. Okay. And if you're out there talking about the trade secrets in your general sense, or you're talking about trade secrets, on your blogs, or and so forth, then you're not keeping it secret anymore. You're not policing your mark. You're not you're not policing the secretness, the secretive nature of your trade secret. So you're going to have to really make sure you're diligent about it. That's the reason why you have to, like, for example, new employees, they have to sign non-disclosure agreements. When you talk to vendors and customers, and you're showing them your products, your software, you just can't willy-nilly go and give them copies of the code. You have to make sure that's done under a non-disclosure agreement. Some agreements that maintain the secrecy. of your technology. You just can't do it in an unfettered way, because if you do that, that shows that you're not policing your mark. You're not taking care of your mark. You're not enforcing your rights. So when you go find out later on that, oh, someone stole my software, someone stole my idea, my formula, my chemical, formula. And said, well, you're going to have to go to court. So what did you do to prove them? What did you do to protect it? And then he said, well, and the defendants are going to come up and say, well, look, he posted on his blog, or there's this customer and he discloses to his customer without any type of protection. That's going to come out, and that's going to undermine significantly your ability to protect your IP. So the next slide, please. So that sort of continues here. Some additional examples of not maintaining the secrecy of your trade secrets. Like I mentioned, posting your proprietary information online, using unencrypted files. That's a big one. If you have your data, even data, just raw data, you've got to keep that protected some way. There's very simple ways you can protect with passwords. There's several ways you can protect with different types of computer access, your data. But if you don't protect it, it's considered to be open. Okay? Non-indexed URLs, that's a big one. Putting it out there on putting it on the internet where it's not indexed, but it's still out there. So if someone knew how to access that URL, they could get access to your file. You've got to keep some level of secrecy. Now, to that extent, if you have an NDA in place or some type of confidentiality agreement in place, and you post it, for example, on a Dropbox, okay, or some type of share file, but the other side, that you're sharing it with has agreed to the terms to keep it secret, that's okay. But you have to make sure that it's a closed environment, that it's keeping, you're not just giving the general public or people who don't know access. So that's why it's important to make sure it's not just you're giving access to whoever has that share file link, but you're giving access to specific people. Okay, I'm only going to give this access to, for example, Kathleen and Allah for this particular data file, but I'm not going to give it to everybody that I don't know who their email address is. Okay, so you got to take those type of protections. Other aspects here, leaving confidential confidential documents in unsecured trash cans instead of shredding them. That's an important one. The case that I told you about where it involved the Gorilla Glass on your cell phones here. Okay. The person who took that trade secret information literally took it out of the trash, put it into a lunch bag, and then took it from the company. Okay. So, you've got to, you have to be to keep, to use a shredder. Yeah, you can buy a shredder over at Office Depot or Staples, pretty readily. And it's kind of a pain. You have to go there and shred the stuff, but use that on your computer. When you're not using your files and your old stuff, you got to delete it. Okay, totally. Don't keep them. Okay, if it's something that you don't need to. And after that, restricting physical access, okay, or computer access. You just can't say, oh no, I just kept it on my open computer. There's no passwords on my files or my folders. No, you can't do that. You have to keep the trade secrets truly secret. You have to show that you're taking reasonable measures to protect the secrecy. And nowadays, when encryption software, password protection is readily available as an option on almost every app, every type of software out there, whether it's Microsoft Word or PowerPoint or Adobe PDF. It's so easy that to utilize. A court is going to look at that and say, you know what, all you had to do was do a couple of clicks and you could protect them, but you didn't. So you've got to make sure you're doing it. And then the last point here, you've got to be aware, you have to investigate your potential misappropriation of trade secrets. You have to investigate who is potentially infringing, your trademark, because don't just wait until, that person who's selling brownie tea. They're only selling it at a small store, down the corner. The sales aren't that big. You know, if you don't wait until they become a giant and they're selling, an infringing product, at Walmart or at Costco, you really have to be diligent about this and cut it off early, because you don't want to be held that you slept on your rights, that you were just conceded your rights to the public, which can happen in both trade secrets. So those are important considerations. So with that, I don't know if we have about 10 minutes left. If there are any other questions, we'd be happy to answer them. We had a couple of questions here, but we're happy to go answer any of these questions now. Or if later on you feel like you want to go and talk to us, maybe more privately, we're happy to do that.
Yeah, so if anybody has any questions, you can also raise your digital hand. I can allow you to talk, or you can post it in the Q&A or chat if you have any. But we have about 8 minutes left. So first of all, thank you so much, Alphonse, and thank you, Kathleen. Very informative. So while people are thinking of questions, so where do you go to register trademark?
That's a
How do
good
you
question. As startups, you can go to the trademark office. It's federal, but it's expensive. All right. A good place to register your trademarks initially, and inexpensive, is at the state level first. The Maryland Secretary of State, they have a website. You can just do trademark registration, Maryland Secretary of State. Okay. It will show you links. You can get it done. You can do it like within minutes online. That's always a good start to register it within the state. At least you'll have a record that you registered it somewhere. And you can use that to show the trademark office, the federal trademark office, that you've been diligent in policing your mark. Okay. And it's a good way of getting your local protection done. That's a good way of starting out first. Okay. So that's one. The other thing is for copyrights, and for your trade secrets. Just before you go to copyrights, trademarks, and your trade secrets, copyrights, patents, and trade secrets. Before you go out and submit your copyright registration, your patent application, something like that, this is a practice tip. Keep everything as a trade secret. Protect the information first. Then you can make an informed decision later on whether you want to disclose it to the Copyright Office, whether you want to disclose it to the Patent Office. Okay, whether those are avenues. But if you at the very beginning keep it as a trade secret, well, then you always have trade secret protection as an avenue of protection. But if you decide at the beginning, I just posted it on the internet, or I just did this, or I gave it, to my buddy because he wanted to go and look at it. He was curious. Well, then you've given up that protection from the very beginning. You can't let that, you have to preserve that protection from the beginning. So I would highly recommend, sort of as a practice tip, as just good IP hygiene, keep everything as a trade secret first, so you can make an informed decision on how to protect it later. So sort of like, if you have a property, build a fence around it, okay, first, even if it's a small fence, or a wooden picket fence, because at least from there, you can decide later on what you want to do. You want to build a brick wall, or do you want to just let everybody, go across it, or do you only want to allow certain people to go across it, or you want kids to go across it, but you don't want your neighbors to park their boats and their junk cars. Well, at least if you fence it off initially and you protect it as a trade secret first, you can make informed choices later.
Yeah, thank you.
But again, thank you very much, Ala, for having us here. And again, we understand that this is a webinar. We have great participants here during our webinar, but it's also going to be posted. So if you're listening to this, as a result of a post, feel free to reach out to Ala, others over at at the university or to ourselves, and we'll be happy to figure out a way that we can help you in a confidential and privileged way.
Yes, thank you. Thank you so much. Oh, thank you, Kathleen. This has been very informative. I know that this is the kind of question that is often very confusing to entrepreneurs, new. If you're not an attorney, you don't necessarily understand what's trade secret, what's trademark, but it's so, so important to, you can build an entire business and then lose it as you showed us, just because you didn't think about these things.
Correct. Yes. It's always, it's fun to build, but it's also easy to lose. So you don't want to lose them.
Exactly. So thank you so much. I don't see any more questions. And if so, thank you so much to everyone who attended and stayed to the end. And thank you again, Alfonso and Kathleen. And I'll share the link with you when it's posted. And if you're watching this on YouTube, please like and share and let us know what other topics you'd like us to cover. Thank you.
Thank you, everyone.
Bye-bye.
Thank you.